Thank you, Trey Lehman. Want to hear from Attorney Cianci before I hear from Mr. Richard?
Thank you, Your Honor. And perhaps to maybe try to answer your question regarding the scope of the rights contained in Article 32, as of course you noticed, there's relatively little case law in New Hampshire regarding this, which is why Mr. Lehman and I resorted by analogy to the First Amendment under the federal Constitution and Supreme Court cases decided thereunder. I also think the Gentry case from Tennessee, which we included with our filing, really is instructive because not only does it sort of concern similar facts, involved a citizen of Tennessee presenting a remonstrance to the Tennessee legislature and then requesting the legislature to take some sort of positive action on that. The court decided that case under a similar constitutional provision of the Tennessee Constitution regarding petition and remonstrance. And also the plaintiff in that case sought a similar remedy as in this case, that being a writ of mandamus to sort of require the legislature to act. And so we would sort of urge a similar result as in that case, Your Honor, because what the Tennessee court found in relying both on the U.S. Supreme Court precedent, cases decided under other state constitutional provisions related to petition and remonstrance, that really the scope of the right, the limit of the right is in presenting the remonstrance, presenting, as Mr. Lehman said, that piece of paper or that email or broadcasting that message or protesting outside the State House to the legislature's attention. However, it doesn't require anything more than that. To the extent that the legislature chooses to take further action, as Mr. Lehman pointed out, that would be within the purview of the legislature under its own rules of proceeding to provide. And we would note under present circumstances, there are no House or Senate rules that deal with the issue of remonstrance. And so in the absence of that, the remedy of mandamus, that is requiring either the Speaker or the Senate President to take some sort of positive action, whether under existing rules or, as the plaintiff suggests, to require this court to mandate that the House or Senate adopt rules to deal with this. We just don't think that's required under the Constitution or any of the cases cited in our motions. Really, and I think the Tennessee court put it best that the citizens certainly have a right to present their remonstrances and their petitions for redress to the legislature. However, that's where that right, that's the limit of that right. It's then incumbent upon the legislature to decide what it wants to do with that information. It may, as Mr. Lehman pointed out, it may, particularly in New Hampshire with 424 members, it may be in the form of taking the substance of somebody's remonstrance and turning it into a bill, or turning it into a proposal to amend the Constitution, or some other action. And that is the mechanism under our rules by which the legislature would take action on the subject matter. There is no requirement that it takes action on the remonstrance or the petition itself. And so that's where we would argue that this court's authority to mandate the legislature to act, whether via writ of mandamus or through injunctive relief, is limited. It's within the purview of the legislature to do that. And just finally, I would note, and I did mention this, we did mention this in our motion, in terms of the plaintiff's remonstrance, even though not required, even though not contained within House rules, the House, in fact, did receive the remonstrance. It did, in fact, post notice of that remonstrance in the House calendar on 2 separate occasions, made it available to any person who requested it, and then in February actually took a vote. A single member brought a motion to the floor to refer the remonstrance itself to a committee. That was up for a full vote in the House. The House voted to table that, and it was not referred to committee. So even though that required, the House did decide to take action, which I think even more so shows that there are mechanisms where if the legislature wants to entertain the subject matter of the remonstrance, it can, but it has the right to choose how to deal with it. And so we would just argue that, sort of by way of analogy with the other provisions, other states, and under the federal constitution, it should inform this court's reasoning and result in this case. Thank you, Your Honor.
Croc TV.